client testify?
I'm not planning on it, but if it's necessary, I will. I think I
All
can.
right. I'll swear her in if you call her. Meantime, Ms. Canedo, be aware that you have a right to remain silent. That means you don't have to say anything. You don't have to answer questions. Do you understand that?
Yes, sir.
All right. And if Mr. Belleville calls you to testify, you're giving up that right. Do you understand that?
Yes, sir.
At least for this hearing. Also, you have the right to demand that this hearing be done in an open courtroom. Because of the COVID pandemic, we're not at this time holding hearings in the open courtroom, but we are doing, you and the state both have the right to demand that. And what we're doing is we're handling our hearings by video conference and being placed on YouTube. Do you understand that?
Yes, sir.
And you're willing to agree, you do agree and consent to doing this by video conference instead of the open courtroom, is that correct?
That's fine.
All right. Mr. Belleville, you have the floor.
All right, Judge. The defendant was charged with a DWI second, and she was required to obtain an ignition interlock device. She asked the court to, and through pretrial, she asked to use a different device because she no longer had access to her vehicle, and the court ordered the Scram remote breath. She asked that the fees be waived, and the court did waive those fees, but she needed to file proof of indigency. Pretrial has been trying to get a hold of her, but she has also been trying to get a hold of pretrial. And she has called me numerous times saying she's leaving messages with pretrial, but nobody calls her back. Pretrial calls me and says they cannot get a hold of her. I do know many of the times when pretrial calls me, the number says no ID, or it is at times it'll even show up as a scam call. But I answer those anyway. So if that's the way she's getting those calls, I can understand her not answering them. What I'm asking today is just to give her a little more time. Just let's set a deadline that she has until this time to fill out this, the proof of indigency and get her requirement. On the second violation report, to me, it makes it sound like she's not contacting pretrial at all, but when she is making an attempt to contact pretrial. And so I would just like the court to, well, we're asking the court to set aside the warrant and reinstate her bond and give her a short period of time to come into compliance.
When was she placed on the conditions?
I don't have that right in front of me, Your Honor.
Judge, I have the D page on the screen. If you want, if you can see them, I can go back to the beginning of it.
It was an affidavit of non-ownership. January
Yes, sir.
14th, January 20th, arraignment. January 20th, arraignment waived. January 26th. Okay. January 26th, motion for waive remote I guess that's the one on the fee. Breast device. Scrum remote was a condition as of February the 4th. February 5th, order and motion to amend order for ignition interlock. Granted, defendant must submit proof of indigency. That order was given as of February the 5th, Mr. Belleville.
Yes, Your Honor. And I contacted pretrial to find out how to go about that. And I talked with the pretrial supervisor, and she said the pretrial officer would take care of that. And between then and now, pretrial's been playing phone tag with my client, and my client's been playing phone tag with her, with pretrial. As I sent with my with the motion, several screenshots of my client's phone where she has been trying to call pretrial. And I would just like everyone to be on the same page, get this done and move forward.
Well, as far as I'm concerned, the obligation for proof of indigency is not pretrials, but it's you and your client.
Well, when I spoke with the pretrial supervisor, I asked her what form she wanted, what form pretrial used, and if they could provide that. And she told me the pretrial officer would take care of it. But if you want me to file something, I will do that.
I suggest that you better.
All right, I will, Your Honor.
All right, I'll give you 1 week to get this done. I'm going to recall the warrant and reinstate your bond. But if it's not in within 1 week, Mr. Belleville, I will reissue a warrant, double the bond, and there will be no second hearing on this. Is that understood?
I understand that, Your Honor.
And Ms. Cañedo, do you understand my order?
So what exactly do I have to do? I don't understand.
The obligation is for you to provide proof that you are indigent. Ordinarily, all you need is a sworn affidavit that is subject to perjury, indicating what your income is and what your expenses are. Do you have children? Do you have children?
Yes, sir, I do.
How many?
I have two. I have a 9-year-old and I have a 5-year-old.
All right. Well, you and Mr. Bella will get together and get this done in no more than a week.
I will do that, Your Honor.
All right, Mike. Anything else?
That is it.
All righty. Mr.
That's-
Edelman, anything?
Next Tuesday, Judge, is May 30th. I'm sorry, March 30th.
Okay. You have, well, let's make it 31st, because this day is already over.
Yes,
I will
sir.
I will have it in before that, Your Honor.
I would hope so. All right,
Your Honor, may I make one observation?
absolutely.
Mr. Belleville was appointed to represent Ms. Cañedo, and that appointment would seem to indicate that at some point she was interviewed for indigency and found to be indigent. Is that not correct?
I would expect that that is correct.
So it would seem that she has already made the appropriate and necessary statements to demonstrate the fact of indigency. So I don't understand why the court wants her to go through that process again.
The previous ones, the applications, are they sworn to?
I believe so, sir, or at least they should be.
Patricia,
Mm,
the application
Not-
for appointment of counsel, are they sworn to?
no, when they submit them to me, they're already signed, but it has a statement on there. this one was done at the jail. But the listing on there says, I have been advised of my right to representation by counsel in the trial of the charges pending against me. I certify that I am without means to employ counsel of my own choosing, and I hereby request the court to appoint counsel for me. I swear or affirm that the above information is true and correct.
Well, honestly, you make a good point, Mr. Edelman, as you are wont to do.
I have my moments, sir.
All right. The court will accept that as proof of indigency. And we will discontinue the requirement for the proof of indigency, Mr. Belleville.
Thank you, Your Honor.
All right. Then we will not have another hearing on this matter.
So you want to recall a warrant and reinstate which bond amount?
The original bond, whatever that was,
Seems that
2,000?
was $2,000, Your Honor.
how much?
2,000.
That was the original bond because it was a DWI second.
I believe so.
Sounds like
Yes,
a
sir.
magistrate down there is not happy with DWI seconds. Was that PR'd?
No, sir. It's a surety bond.
She made a surety bond of $10,000.
No,
2,000, Your Honor.
2,000.
Oh, okay.
Bill
I
submitted.
heard 10. I'm sorry. All righty. Good enough. Reinstate that $2,000 bond.
Thank you, Your Honor.
All righty. Anything else?
No,
Nothing from the state, Your Honor.
All righty. Patty, we have anything else?
No, sir.
All right, then we will see each other or contact